May it please the Honourable Court, I am Muhammad Khazali, acting as DPP in this case. On my side, I would like to ask for court in favour to impose heavier punishment for the offender in this case. Your Honour, accused has been charged with an offence under Section 11, Subsection 1 of the Prevention and Control of Infectious Disease Act 1988 for contravening Regulation 3, Subsection 1 of Prevention and Control of Infectious Disease Declaration of Infected Local Areas Order 2020, and on conviction shall be liable to a fine not exceeding Rm 1,000 or to imprisonment for a term not exceeding 6 months or to both. Your Honour, the first ground that I would like to state are in regards whether the offence made by the offender considered a serious offence or not. Your Honour, prosecution pray for the courts to impose heavier punishment to the accused as the offence made by the offender was serious in nature and has given threat to public safety. The first factor on why it was deemed as serious offence can be looked at the rampancy of the offence. On 5th of April 2020, accused was arrested at Kubang Pasu Kedah as he offended Regulation 3 Subsection 1 of the said regulation by moving from one place to another place within an infected local area for a purpose which is not provided for in Regulation 3 Subsection 2. The rampancy here can be seen as it was considered a serious offence, where the order has been made by the Ministry of Health for the citizen to not move from a place to another as to avoid of being infected, but the offender did not oblige with the order, thus making it higher in risk for the infection to be spread. This can be referred in the case of Cheong Ah Cheow versus Public Prosecutor, where the court imposed the maximum fine of Rm 20,000 for betting offence because the rampancy of such offence. The second factor, it was considering a serious offence as it was involving the public interest. It was duly noted that COVID-19 is on the rise via human transmission. Thus, Part 1 of the first Schedule to Act 342 declares the state of Kedah to be an infected area, as all states and federal territories in Malaysia are threatened with an epidemic of an infectious, namely COVID-19. Thus, in order to protect the public, the restriction of movement has been applied. This can be referred in the case of Irwan bin Abdullah and others versus PP. The accused were sentenced under Section 25, Subsection A of Fisheries Act 1985. High Court held the sentence imposed was totally fair, as taking account the issue of public interest and the protection of natural resource. Your Honour, the second ground that I would like to state was in regards whether the offender should be imposed with heavier punishment or not. Your Honour, prosecution pray to the court to impose heavier punishment to the accused as the offence made by the offender was serious and the effect can be severe toward the public. The first aggravating factor that prosecution think that the offender shall be imposed heavier punishment is due to the deterrence for the sentence. As stated before, that the offence made by the accused was serious in nature. Thus, prosecution argued that the heavier punishment would be suitable for deterrence as to deter the offender and future offender. It will show the public the impact and consequence of neglecting the order. Prosecution referred in the case of PP versus Lu Chang Hock. The accused was 18 years old at the time and convicted for 2 offences of housebreaking. Trial judge sentenced him to 6 months of imprisonment and a fine for each offence. Public prosecutor appealed to the High Court and judge has increased the sentence to 2 years of imprisonment and a fine of Rm 5,000 for each offence and view it as deterrent sentences. Second factor would be the previous conviction or bad record of the offender. Referring to Section 176 Subsection 2 Clause R of the Criminal Procedure as follows, The particulars to be incorporated in the record shall include the court notes on previous conviction, evidence of character and plea in mitigation if any. Thus, by looking at the previous record of the offender has a prison record as he was once convicted with the offence of self-administration under Section 15 of the Dangerous Drug Act 1952. He was sentenced with Rm 1,200 fine and has undergone 2 years of supervision. Therefore, heavier punishment should be imposed as he has bad record in crime, and it shows that the offender should be imposed heavier punishment to avoid repetitive crime to be occurred again. Referring to the case of public prosecutor versus Ja'far bin Daud, Judge Muhammad Azmi enhanced the sentence from 8 months of imprisonment to 18 months of imprisonment to the accused for possession of heroin, as the accused had 5 previous convictions. Therefore, the prosecution humbly requests to court to impose heavier punishment as to give lesson to the offender, as well as public, and to prevent further offence from being violated again in the future. Prosecution referring to the case of public prosecutor versus Roslan Imun, where the accused was charged with an offence of voluntarily causing hurt under Section 326 of Penal Code, and sentenced the accused for 20 years imprisonment and 20 strokes of whipping on several aggravating factors, including previous conviction of the accused, type of the offence, and the fact of the offence was premeditated. That's all from the public prosecutor. Thank you, Your Honor.